Well, a plea deal for testimony, something we see from time to time in the court system.
You know, one case in Knox County recently came with a twist. The person testifying, George Thomas, had already been convicted in the double murder, rape, and kidnapping of Shannon Christian and Chris Newsom. Thomas took to the stand and implicated Eric Boyd as a fifth player directly connected with the murders. In the end, Boyd was convicted on 36 counts. Anchor Lori Tucker diving deep on how this deal came together with some help from WATE 6 News side legal expert Greg Isaacs.
Greg Isaacs, thank you for being with us.
It's good to be here, Lori.
So George Thomas walks out of the courtroom this week with 77 years of his freedom back. How did that work?
Wow, George Thomas had been convicted in the Chipman Street horrific murders, slayings, tortures, and years later he becomes the pivotal witness against Eric Boyd. Thomas was facing 2 life sentences plus 25 years. Here's what happened. The prosecutors offered him a sweetheart deal. He'd already done 12. We're going to reduce first-degree murder to second. We're going to reduce the rape case to aggravated assault. Now you have a real chance of getting out of prison. But lo and behold, Judge Kurtz, hearing the deal, says, stop. There is no legal basis for me to approve this plea agreement.
What a moment in court. Could you just put yourself in their shoes?
That's the oh blank moment. He says, I don't have the legal authority. You better do some explaining.
Yeah.
I want some legal briefs, and let's come back a few days later. Fast forward, the prosecutors and defense lawyers enter into a memorandum of understanding. They argue that under the Post-Conviction Relief Act, the judge had broad authority to issue what other orders that are reasonably necessary. But Lori, here's the kicker on this. Under the law, there are only 2 ways to get out. One, after your time for appeal has run or your last appeal is denied, you have a year to file a petition for post-conviction. That's heard in the trial court. Typically, you allege there's new evidence, your counsel was ineffective, or the trial court made serious errors. Then that can be appealed to the Court of Appeals and Supreme Court. You could also file a Rule 35 motion in 120 days after a conviction. That cannot be told, cannot be extended under any reason.
Interesting.
But it had been a decade since this time frame had run out.
So how could that happen?
But the judge lets them do it, and the prosecutors, here's what the interesting legal thing is, argued that you have the authority under this Post-Conviction Act, since there was a petition still pending, to either grant the petition. Judge said, no, I can't. That'd be a legal fiction. Or do what other orders are reasonable and necessary to set aside his jury verdict conviction and resentence him. Now, Lori, here's the rub that hadn't happened yet. If I'm a person and I'm incarcerated and I've got nothing to do but think, if I'm sitting there going, I've been resentenced. I have 30 days until the judgment becomes final. Then I've got 30 days to file an appeal.
Looking for loopholes.
I've got, this actually could give him another chance to attack this new judgment. Now, he would probably be foolish because, he got a sweetheart deal to testify against Eric Boyd. Again, he was the darling of the prosecutor's case, but maybe he says, I have nothing to lose. I've got a new judgment, a new chance for appeal.
Do you think that could happen?
It could happen. Who thought this could happen?
Right.
But recently in Davidson County, prosecutors agreed and defense lawyers and a judge to set aside a death sentence in a case all within the same week.
Okay.
But very interesting legal maneuvers in that very terrible Chipman Street case.
Yeah.
But give the prosecutors credit. They stuck to their words, stuck to their guns, used Thomas to get a conviction against Boyd, and now tried to do the right thing.
All right. Greg, thank you.
Thank you.